All right, so we're joined by a very special guest for a brief discussion here between panels. The Director of the United States Patent and Trademark Office, Andrei Iancu, has made some time, and as he described his very whirlwind schedule here at South by Southwest, to join us for a brief fireside chat, sans the fire, although we should have had a cactus or something. Before we get into any patent-related questions, I saw on Twitter that you rode a jump bike over here. Tell me about that.
Yeah, so I rode a jump bike last night, not over here at this moment, but yeah, we had a few blocks to go, and we thought that taking a cab or an Uber car service, it would take us too long. So we tried to figure out the bikes, and we got on one, and I do take pride that I got mine to work. Our communications director, who I don't see right now, Chris, is back there. Yep, there he is. He couldn't get his to work, so we're very proud about this. But it was really, it was great fun.
And I have to ask if you've been on any of the scooters.
I have been on a scooter, but not here. I've been on a scooter back home in Los Angeles.
And are you getting back on one again, or was it a one and done?
I don't know about the scooter, but the bike I really enjoyed.
All right, well, we'll get into patents here. You at the USPTO recently issued your 10 millionth patent. And I always tend to be quality over quantity, but that is no small achievement by any measure. I want you to reflect on that a little bit and then look to the future. Is that patent system that gave us 10 million patents, is it equipped for the next generation of inventions in artificial intelligence, machine learning, robotics, or does it need to adapt and modernize?
So the 10 millionth, which we issued last summer, it really is a monumental achievement. It's 10 million. Obviously, it's a nice round number, so it gave us a cause for having a little celebration. But it gave us pause to reflect on the past 200 some years since the founding of the country and the establishment of our patent system. If you think about it in the grand scheme of things, put it into the context of human history, everything that we are so used to having today, electricity, lights, right, air travel, bicycles, literally everything that we are used to right now has been done since the establishment of this country and our patent system. And the vast majority of them have been done with US patents. I like to say that humans have been around this planet for a very long time, right? Thousands and thousands of years. We've had human civilizations for a very long time. The Egyptians, the Mayans, the Aztecs, the Greeks, the Romans, and the Hebrews, all that. Yet the state of the human condition when this country was founded at the beginning of our patent system 200 and some years ago was basically the same as it was in ancient Rome. Right? And it's really since then that we have come where we are today with instant communications. Look, they're all using them.
Eyes up, guys, eyes up.
Right now. Paul's already instantly posting on Twitter as we speak. Instant communications, modern surgery, modern medicines, everything. So I don't think that humanity knows progress the way we're used to it without the US patent system. We just don't know about it. It hasn't happened. So, so if I had to bet, I would bet on our patent system for the future. Now, does that mean that we don't have to make changes? Of course we have to make changes. So looking forward to the second part of your question, into the future, we are on the cusp of the next industrial revolution. In fact, we're at the beginning stages of it with artificial intelligence, autonomous vehicles, quantum computing, biotechnology, and the like. Yeah, so there are things that we need to look at, and we are looking at right now. The volume of innovation is much higher now. The volume of patent applications that we get is increasingly higher. So we need to deal with volume. So we need additional tools for us to be able to process the applications in a high quality way. We need potentially to assess the policy implications of artificial intelligence and how the laws need to change surrounding the patenting of some of these technologies. We do have at the PTO a task force right now that is looking exactly at these issues.
Could you elaborate a little bit more on the laws needing to change? Particularly, how would you envision Congress lawmakers needing to wrestle with some of the issues around artificial intelligence as it relates to patentability?
Yeah, so if you think about it, I'll just give you a couple of examples, right? So there's a question about inventorship, questions about ownership, right? So you have machine learning, and at some point, machines will be able to create the next advancement in technology. And at some point, machines will be able to create an advancement in technology that is meaningful enough to be entitled to a patent. In other words, a machine might make a non-obvious variation of existing technology. All right then, so who is the inventor in that case? Not only that, who owns that technology, that innovation?
Yeah.
Is it presumably not the machine? Although maybe it is the machine who owns the new technology. But if it's not the machine, is it the current owner of the AI algorithm that created it? Or is it the original programmers and so on? So those are some examples. There are questions of disclosure. The patent system, as we've ever known it, requires a quid pro quo. You, as the inventor, are disclosing fully to the public what your idea is and how to make it in sufficient detail such that one of ordinary skill, one of your peers, more or less, can actually recreate it without undue experimentation. That's your obligation to do when you file a patent application. And in response to that, government issues you a patent if you meet all the statutory requirements. Okay, well, with some artificial intelligence technologies, we don't actually know how they work to some extent, or how they do get to their results. To some extent, there's black boxes.
Yep.
Well, how do you make those disclosures in that case? And what would be required to get a patent in that kind of situation?
And is this something that the Patent Office alone is going to be able to tackle? Are you already working with industry on these problems, or is that something that Congress really needs to step up to?
I think everybody needs to attend to these issues. We are right now just focused on surfacing the issues. We want to surface the issues, start circulating some thoughts, some ideas. For some of these things, it may be that we can handle in the administration. For some other things, we may need legislative fixes. Yep. For any changes in this and other areas, we always want industry input and the input from academia, because in the end, we're all here for industry.
Yep.
We're here, I mean, we need to support all of you.
We appreciate it.
All of your work, and so we need to know where industry wants to go. But the first order of business is surface the issues.
I want to get to an issue that you're particularly passionate about and that you've been outspoken about, and that's the fact that invention is not confined to any one location in the country. It's not confined to any one demographic. You know, frankly, we've been talking about how, as an industry, we still have a diversity problem, and we need to get to a better place with full representation, particularly when it comes to founders, you know, the inventors of this technology, the founders of the companies. I don't want to put that problem on you. That's for our industry, the venture capital industry, to step up and tackle. But you've been very outspoken about what the Patent Office is doing to help. Talk a little bit about what you're doing to try to democratize that innovation, make sure that it's open for everyone.
Yeah. So as it happens, I do think that innovation in the United States is quite concentrated. It is concentrated geographically, obviously. In certain pockets, it is concentrated demographically and also economically. Mm-hmm. And we have just a couple of weeks ago, we published a new report on the participation of women in innovation. What we measured is the number of women on US issued patents over the past few decades, all the way through the end of 2016. And we've seen some very interesting trends. So first and foremost, we know that the engagement of women in the STEM workforce, just at large, before we get to innovation, just simply working in computer science, engineering, and scientific fields and so on, is on average at about 25%, give or take. So that in and of itself is a little bit low, right, or quite a bit low, given that women make about 50% of the general workforce. But beyond that, our study shows that women in 2016 made up only 12% of inventors named on US patents. That's average for the whole nation. So first point, even though they make about 25% of the relevant workforce,
which already is an issue in itself.
Which already is an issue in and of itself, they appear on US patents at half the rate that men appear on a percentage basis.
Wow.
So they're inventing, if patents are a measure of innovation, they're inventing at half the rates.
Have you dug into why that's happening?
So our report does not. Our report just puts out the numbers, and we don't, we're the government. We don't pretend to know what's going on inside businesses, but we have seen a few trends. So the other interesting point is, so the 12% is an average number, but the numbers are concentrated by industry. It's better in the biopharma industry, in the biological sciences. The participation of women in innovation there is a bit higher. It's closer to 30% or so. Still lower than the engagement of women in that workforce, but still higher than average. It's particularly low for the tech industry. And anyway, you can take a look at our report. It's on the website at uspto.gov. It's on the front page. And you can see certain industries, how they perform. And you can also see certain companies, how they perform. And actually, we also rank by state.
Oh, wow.
States do better at this than others.
Well, I look forward to digging into that, and hopefully we can be there as a partner as you work to rectify some of these issues.
Yeah, so I think it's really important that government, industry, and academia work together to try to address these issues. It is so important to spread the innovation ecosystem broadly, and we really need to spread it demographically, as we have just discussed, geographically, so that the various pockets of innovation spread and grow. We create more and more pockets. Austin, for example, is a good example of that success over the past few years. We need more such examples. And also economically, there are studies, not ours, but there are studies out there that show that children from lower income households innovate at significantly lower rates than kids growing up in wealthier households. But overall, more needs to be done across the board.
Well, I don't want to end that portion of the discussion because there's so much more that we could go into. But time being limited, I would be remiss if I didn't bring up patent trolls. We have an audience full of tech entrepreneurs, people that work at tech companies. Unfortunately, a lot of them have personal experience with this, right? They may be named inventors on patents, but they're spending their time and their legal team's time fighting these junk lawsuits. And for those of you that haven't experienced this, when I say patent trolls, I'm talking about entities that use patents simply as a weapon in litigation. They're trying to use them for a quick shakedown. What can we do to make sure that moving forward, our patent system gets back into the hands of inventors, that it's really for the inventor and it's not for their patent lawyer, right? We prevent people from weaponizing these things, and we get back to making sure at their core that a patent is about inventing something and then creating something wonderful, something that really benefits people.
Yeah, so a patent and the patent system in general needs to be carefully balanced. We want to make sure that we have a system that incentivizes that original innovation, that gives the inventors the right to their original innovations, that allows investments to be made in such innovation with a level of confidence that if successful, the benefits of that investment can be recouped, and all those things. At the same time, you want to make sure that you prevent abuses in the system. And you are referring to a particular kind of abuse. We want to make sure that we identify, surface, and deal with any abuses in the system. So there are a few mechanisms that there are a few things that have already been done by the courts, also through the legislation, and to address this issue. And we have certain mechanisms in place to try to address them. So you're familiar, obviously, with the PostGrant Proceedings that are available at the USPTO.
I can see some companies that have actually used these proceedings over there. So, yeah, they're enormously important.
Right. So the purpose of the statute that created these PostGrant Proceedings is to create a less expensive, faster alternative to district court litigation. So what we want to make sure the PTO is that we stay true to that congressional intent, so that if folks are involved in a district court litigation, if they choose to, they can take an accused infringer, as you're identifying. They can try to perhaps hold that thing off for a little while, avoid the big expense of district court litigation, and if they choose, they can come to the PTO and have this alternative venue. So we want to make the process as efficient as possible, and provide standards that allow for an overall holistic, if you look at the system holistically, significant efficiencies, so that you don't duplicate efforts and the like, so that you really have a true alternative and less expensive path to resolution.
Well, again, we could spend an entire afternoon up here discussing the nuances of these issues, but certainly just reiterate the enormous importance of those post-grant proceedings for our industry and the entire efficient functioning of the patent system. I want to end on a note, though. You guys always have a great presence at CES. The USPTO is the gold standard of a government agency involving in CES. You have a great booth every year in the Eureka Park section, which, if you all haven't been, it would be the world's biggest startup show if it stood on its own. It's an entire exhibit of people from around the world creating some of the most amazing things. And the USPTO locates right in the middle of that. And you get out and you talk to all these people. I know, unfortunately, you weren't able to be there this year because of some unfortunate shutdown circumstances. But if it was in Eureka Park in past years or somewhere else, what are some of the most exciting, forward-looking inventions, the things that make you show up at the office and get really excited every day?
Yeah, boy. There's so much innovation going on, and it's coming through the USPTO. I like to say that through the doors of the PTO walks our future, and indeed it does. There's so much and so much excitement. So we discussed some of this in your couple of questions ago. So one of the most exciting parts is that in today's world that I see is the convergence of technologies. And you're talking, on the one hand, you have biotechnology, with genetic engineering and the like, converging with the computing world is just one example. And this convergence, the scientists have figured out the science of DNA within our systems, and the computer scientists have figured out the computing, and this computing speeds have also increased. The statistical analysis has improved. This is allowing for an unbelievable growth spurt in the health industries, to be specific, and creating a new world of treatments and cures and the like. So that's really exciting. The autonomous vehicles, it's unbelievably exciting. It's not just cars driving around towns or drones that are flying around. It permeates industries. A couple of months ago, I was in Fargo, North Dakota, and a few weeks ago, I was in Des Moines, Iowa. There's so much innovation going on in these spaces across the country. So, for example, the use of autonomous vehicles and artificial intelligence for agriculture. And for the improvement of the food supply. Folks are talking about the world growing to 8 billion people in just a few decades, how are we going to feed all these people? Well, it's this type of technology and the evolution and the rapid growth and convergence of high technology, computer science, biology, unmanned vehicles, all of these things working together to really advance the state of the human condition. It's really exciting stuff.
Well, I'm certainly looking forward to a continued dialogue on these issues and a continued partnership with the USPTO, which is just such an enormously important agency for our member companies. But I do want to give the audience a chance. I think we have a couple minutes, maybe one or two audience questions before the director has to catch a flight back to DC.
Hi, my name's Jeff Harden. I have 7 patents, and they're right here.
All right,
Oh, hey.
under the latest cover too, look at that.
And your signature is on this last one, so
Awesome.
So thank you for that. Yeah, I'm also on the advisory board for the Inventors' Rights Coalition, and I've been kind of tasked to ask you a pretty specific question. Okay. And so I have it written down so I won't get it wrong. So Supreme Court Justice Sotomayor said last month in return mail in the oral argument that it seems like the deck is stacked against a private citizen who's dragged into a post-grant review proceeding. No inventor, when they entered into the patent bargain with the government and disclosed their invention to the public prior to the American Invents Act, agreed to the substantial rule changes introduced by the AIA applied retroactively. Do you think it's fair to change the rules in the middle of the game and institute an IPR on a patent having a pre-AIA priority date, given that the inventor did not agree to those rules? And the reason why I ask is because you, as director, have the power to deny institution on an IPR. And when you entered office, you took an oath to support and defend first the Constitution, not what may be bad law, but first the Constitution, where the clauses of due process, takings, ex post facto are immediately present. So, you know, inventors holding pre-AIA patents did not subject themselves to the provisions of that title, the American Invents Act. And now the reliance, which you're so big on, might be something that the value is kind of lost. So I was wanting to know if you could kind of speak on that.
Sure. So a couple of points wrapped in there. Obviously, the AIA was passed by Congress, and it went up to the Supreme Court in the oil states case, which issued, let's say, 10 months ago or so, finding the statute constitutional, at least with respect to patents filed after the AIA. What you're referencing now are patents that were filed for or obtained prior to the AIA, and the question is, well, inventors you're asking for inventors who didn't subscribe to the AIA, didn't know anything about it, now this is coming along and challenging the validity of those patents. Now that issue is currently teed up as we speak for a court decision. We're in the midst of that litigation, so I can't actually comment on the pending case. It is a pending case. But I will just say that obviously as an administrative agency, we're going to enforce the laws that are on the books.
Well, it's not a patent discussion without getting into case law. I had hoped we might be able to skirt around that, but here we are. One more question.
Hi. So I actually have another question about IPRs. I'm a former patent litigator, and one of the issues we came across is always being unsure of whether or not a stay would take place when an IPR was instituted. I mean, the case law is split, it's very discretionary, and litigants seem to have some confusion about whether or not they're going to just be able to litigate in one proceeding or they're going to have to double the efforts. Do you think the current state of the case law is tenable? Do you think Congress needs to step in and kind of clear this up? Or is it something that the PTAB can do themselves? That's my question.
If you're talking about stays of litigation while the PTAB proceeding is going on, obviously the PTAB cannot dictate to a district judge how they should handle their case and their docket. However, I do believe that it is important for the IPRs to achieve their true congressional intent, to be an alternative, cheaper, faster way to resolution than district court litigation, not always an addition to all of that, because that would just simply multiply the proceedings and multiply the costs to everyone. So we have taken certain steps in the past year at the PTO on IPRs. to align standards between our proceedings and the district courts, so that district court, if they see that there is a proceeding going on at the PTO that is on all or many of the same issues that they have, if we're applying the same claim construction standards, for example, maybe they'll be more inclined to wait and see what happens with us as well, especially if we might get to a resolution faster. Similar might be, depending on the positioning of the case, the other way around, right? Maybe the district court is on the cusp of a decision themselves. Maybe we wait to see what happens over there. Overall, holistically, what we want to do as a system, really, I think it's important to achieve greater efficiencies overall, so that the folks involved in the IP system, in litigation and the like, overall can be more efficient and spend less money on the whole system.
And with that, unfortunately, we're at our time. Everyone, please join me in thanking Director Andrei Iancu for joining us. Thanks, really appreciate it.